Okay, try. Let me see.
Audio check. Can anybody hear us online?
Yeah.
All right, guys. Sorry, guys. Redo.
All right,
Start over.
we're completely over. Okay. I'd like to have a roll call vote from my left.
Keith Whittington, Johnson City.
Andy Allen, Kingsport.
Mark Broad, Knoxville.
Jim Ransom, Memphis.
Reese Smith, Franklin.
Carter, Nashville.
First thing on our agenda is to adopt it. Couple of changes. After applications with factors. Hill hiker application extension on the license. After the legal report, then discuss other revisions to be published.
Make a motion, we accept the agenda as amended.
Second.
All in favor, say aye. Carries. Start with approval of the meeting minutes from the last meeting. Discussion on that. Motion for approval.
Second.
All in favor, say aye. Opposed? Approved. Did want to mention the last item on the agenda is public comments, so if there are any public comments, bring those up. Review the license approvals. Motion for approval.
So moved.
Second.
All in favor, say aye.
Aye.
Carries. Contractor revisions, increases at class, no change in name change.
Motion approved.
Second.
Discussion. All in favor, say aye. LLEs, LLPs. Discussion on those. Approval.
Second.
All in favor, say aye.
Aye.
Carried. Up to, added agenda item for hill hiker. They applied for a license. Didn't want to provide a review financial statement. We granted them a temporary license. Has expired once and extended once. They have not completed their work. We're asking for another extension. Close to starting. It's 2 weeks worth of work. Project in Tennessee. Given $1,250,000 temporary license. The project in Tennessee is asking for an extension. Possibly give them an extension to the next meeting. Touch base with that meeting. See. Question for the board is to be an extension. Extended.
Move to the application first.
It's February.
I think the first one was created a year ago.
months, and that expired March. Extension was granted until
So they've had him time.
years.
They can good standing.
They are. Owner, it's a lake property that he wanted to put a sort of electrical access. They've been working on trying to put all the infrastructure in place before the government. That's why we don't do it. Because you haven't. They said we're about to. I think they've done. Correct. The owner apparently has cancer and health issues. Wants to be there with installation.
I may add a few details as well for consideration, because this is legally a strange request. Strange by meaning it's not something we typically see with temporary licensing. You all will recall with the temporary and hardship license, it's a mechanism for an individual to obtain a contractor's license before essentially they can get that immediate license, and it's a way to get on track for full licensure. This individual doesn't really seem to have the intent to obtain a full license. They don't do general contracting in Tennessee. They're actually licensed in several other states in good state. They have disclosed that they are mostly a supplier of materials, and that this project was one that I guess the owner wanted them to install themselves instead of having someone else install it. One other thing to consider, we did ask them, just looking at the installation piece of it, because this is a large elevator, how much, if they were to estimate how much work it would take to do this installation, they said it would be under $25,000, which would be under licensure requirements. So if they truly were a supplier for this contract, someone could come in essentially and install this without a license. So it is because of the cost of, I believe, all these materials. That's where this is really ballooned in value of the cost of this project. But I do think that that is relevant to consider, because realistically, you're extending this because the cost of materials are so high. Considering extending because the cost of materials are so high compared to the actual installation. And one other thing to consider with this as well is that as part of this project, they've got a few different avenues they could legally proceed with. They have asked for the extension. They could, based on the amount of the license, if they were to submit the financials to go towards full licensure, which is basically the avenue for temporary licensing, they would have to submit a review financial statement. They've expressed that they don't have a desire to do that based on the cost of it. Would essentially exceed the cost of installing the rest of this project. Likewise, they could also truly act only as the installer, the material supplier for this, basically cut the installation piece off. Someone else would come and install this, either a licensed contractor or unlicensed if it's under contract. And they didn't really seem to have a desire to do that either. It sounds like the homeowner wants them to be the one supervising this, which essentially puts them as a project manager, require a license. So even if they tried to sub it out, they would still need to have a license for this. So you all do have the, you could extend it, you could extend this temporary license, not necessarily supported by the mechanisms in law to do so. I think you could grant that extension, or if you did not want to grant the extension, this temporary license would expire at the end of this month. They would have to find someone else to come and do installation. But it sounds like everything is ready to go according to them. It just needs to actually be installed and work with the homeowner to have that supervised. Does that make sense in terms of what your options are?
Did say that they tried to find. So. Such a small project. Contractors in this area.
And I think this is a very specialized type of elevator as well, the way that it sounds, it's been described. I think they have sent some pictures to want to consider those at some point, but it is a big elevator for a wheelchair.
That's the board.
I move for. license extension.
Second.
All in favor, say aye.
Aye. Mark, I've got application back.
Oh, yeah, guess I skipped that, I'm sorry. Go ahead, Keith.
License number 63111, in Image Construction. Got a monetary limit of 300,000. Applied for a monetary increase of $1 million. Unlimited dollars. And their experience bills, they spent several projects that were well over current monetary license. Market review case and made a recommendation. They still came before the board this morning and wanted to question that they didn't understand exactly what the monetary limit meant, didn't mean to do anything wrong, but we agreed to leave the fine as it was, and once the fine is paid, they will receive their monetary increase.
What's the fine?
Fine is $3,000. $1,000 for a project that was listed. And I told them, Mark, really taking it easy. So I moved that one to be approved.
Any other?
Yeah, that's all.
Application. back. Got to discuss. First one is non-home builders, file number 81875. This is a house flipper. It's also a realtor. Started a construction company. License for a while. Does have some violations. Set order for $1,000. This one was something called SCER LLC. But their previous license expired. Finance against it. Got all of those complaints closed except for one. Going to issue him a license so he gets that complaint satisfied. Sat in with me on this one. He's going to check to see possibly subs that were company. Almost they working. Just follow up and check. Point. Indicate if we can get the complaint. Say settle.
There was one prior complaint that was flagged by this board at the 2 meetings ago. That complainant did not cooperate with the investigation. So we're going to confirm that has been resolved, and I can follow up with all the things that you just mentioned. There's no outstanding litigation, and that he cooperates with the one pending complaint that is open. I can follow up with everybody on that.
Assuming all that checks out.
Lee and I interviewed a couple of new applications. One was home improvement that brought to our attention. And they had been working without a license. That was actually the previous owner of the company and not the new owner. We now have the information on the previous owner that is still doing business in the state in some manner to And so we approved that is a home improvement license. That's file number 11976.
We also had, new applicant, Blacker Homes. Blacker was building homes, wanted to increase his license. Still given a limit of $125,000 due to his experience. We approved his license.
To 300.
All right, I'll take a motion to approve the application. Factors as discussed.
Motion.
Second.
Favor say aye.
Aye.
Opposed? Brett, RCE provider reviews and force approvals. Two of them.
Yes, one is a renewal. Right, so All-Star training online is a provider. You know, it's a renew every 3 years.
Make a motion, we approve RC drivers.
Second.
All in favor, say aye. Legal report.
Yes, we had I had a few changes. Number 54 on the legal report, that is case number 2024-039341. I inadvertently left the recommendation off of that. It should have been closure. And the board is going to concur with that, so the decision is to close. Number 73 in the legal report, that is case number 2024-039641. That was set for discussion, and after discussion, the board considers that matter more of a civil dispute and not rising to the level of any workmanship that the board can consider. So the board is deciding to close that matter. Number 96, that is case number 2024-032611. The board is concurring with the closure with a letter of warning, but also opting to open up an administrative complaint against a licensee, and that is license number 25864, and authorize disciplinary action against that licensee and a settlement offer of $250 civil penalty.
There are additional changes. Case number 90 on the legal report. That's case number 202-0037961. The recommendation is to close the letter of instruction instead of letter of warning. And case number 91 on the legal report. That's complaint number 2024-9121. Recommendation is to close file.
There is one other matter we'd like to bring to the board's attention, or really just for consideration. We'd like the board to consider authorizing only complaints where revocation or suspension has been authorized, for the board to only consider hear those matters at hearings. As you know, we have a lot of complaints that come in, ones that are more minor and where civil penalties are just authorized. We want the board to consider to allow ALJs to hear those even against licensees. If you have authorized revocation or suspension on the legal report, we believe the board has to still consider those at hearings. But for more minor matters where only civil penalties are authorized, we want the board to consider allowing those to go to ALJ. So if that's something the board would want to consider, I think we could get a motion to authorize only anything other than revocation and suspension cases can be heard by an ALJ alone. So if the board wants to discuss that and then potentially make a motion, if you have any questions for me, I'll be here.
What's the current criteria?
So right now, if it's against a licensee in a hearing and they don't settle with us, then and if it goes to hearing, it's got to be set in front of the board. So what we want the board to consider is that even if it's a licensee, if the board has not authorized a revocation or suspension and just a civil penalty, then that matter can be decided and heard by an ALJ instead of in front of the board. Now, matters where the board has authorized a revocation or suspension against a licensee, that will still go in front of the board. So that's a consideration. We believe it would, as you know, we have a lot of complaints and stuff that is more minor where civil penalties are just being issued. It would be more effective to get those cases heard by LJs. And I think it would also, this is something to consider, if there is a matter, even an unlicensed matter or a licensee matter, that where the board has only authorized civil penalty, if you see something on the legal report that you would like to hear, even though it's not revocation or suspension, I think you can make that decision while we're reviewing the legal report. Does that make sense too?
Question on that?
So I think all the cases that you've heard this year have been revocation cases. So it would allow for some of those backlogged in other cases where they're just seeking civil penalties. Instead of us having to get those lined up for board meetings, we can allow ALJs to hear those and resolve those through hearings.
If it's helpful to just kind of look at some of the different violations. We get a lot of complaints regarding, a contractor who's not followed a warranty or who has failed to respond to a complaint. Some of those cases, I think are things that ALJ would hear. If there's a situation with workmanship that we think the board really does need to hear, if it's still a penalty being authorized, those can still file those for the board. We filed unlicensed cases, but there have been just some concerns that it makes more sense for the board to hear it than an ALJ. So those types of decisions could still be made. But I do want to add though as well, if an ALJ hears a case, and you'll see this later on the legal report, so it might make a little bit of sense that we're discussing it this way. If there's a case that heard by an ALJ, after the conclusion of that, they issue an initial order. That initial order does not become a final order if it's appealed. And if it's appealed, then the board then would have to issue a final order. So if there was a situation, for example, where it was a gross negligence case where there's a contractor who did something deviated from the standard workmanship, we said it was gross negligence, goes to an ALJ, and maybe they don't find that way. The board would still have the authority that we could appeal that to the board and say, we do want the board to reconsider this. I think the ALJ was incorrect in these findings. It makes more sense to have the expert or expertise of the board to review that. So basically, this would alleviate those cases where previously any unlicensed case was going to the ALJ, any licensed case was going to the board. We had a case, I believe it was last year. No, it was just about 6 months ago that the board heard where we presented it for revocation. The board decided to issue a civil penalty instead.
And that's on the addendum.
Which is also the addendum case as well.
We're going to discuss that as well.
And we just think it would be more time, more efficient on some of those cases. If they're exceeding the license limit, not responding to a complaint, not honoring a warranty. Those are things, certainly the board does have expertise in those areas. We also think an ALJ could hear those, issue an initial order. If it gets appealed to the board, great, the board would still review it, not really saving time at that point. But all those other matters could be resolved more efficiently by setting those on the ALJ schedule.
But we're still reviewing these legal reports.
That's correct.
Is that correct?
That's correct.
Okay, so we can determine it at that point in time as well. So
Correct.
If there's something you see on there and you want to hear it, even though it's not a revocation or suspension case, you can certainly make that decision after reviewing the legal report.
What's our turnaround time from receipt of the complaint to decision that we're going to go for revocation to the formal hearing?
So all complaints we have to present to the board within 180 days. Most of them are presented way before that. I would say on average about 60 to 90 days. In some circumstances, it may be closer to the 180, but they're all considered by the board as far as what decision you're going to initially make, whether you're authorizing discipline and what settlement offer you're going to relay. That's all within 180 days. And then after that, it could be anywhere from 3 months to a whole year out by the time we can set that for a board meeting. The ones that can be resolved by ALJ alone can be set a lot quicker because you don't have to align with board meetings and that kind of stuff.
I don't want to shoot the messenger, but you're telling me it could be a year time somebody complains. So then we can even hear,
If it was a revocation or suspension case, we get those.
the guy could be practicing,
Yes,
the guy could be.
technically. If we had so many of those cases that are scheduled for hearings, it could be to the point where you may have to have a 2-day board meeting if we've got to get those heard. But yes, there could be the situation where it is.
Should that protect the public?
Well, by allowing some of these more minor violations against licensees to be heard against ALJs, that would free up some more room to make sure these matters that need to be heard very quickly can be heard.
Recent out, we've said. Problem. Solved.
Okay,
Okay.
To make that.
good to know.
Formally vote on that?
Yes, I think if someone could make a motion to authorize all other matters besides revocation and suspension to be heard by ALJ alone. That covers that. So if someone wants to make that motion, then
Make a motion that the board authorization.
yes,
I think the board should authorize the legal team to present only cases that involve a suspension or revocation to the board and let the legal judges handle the other cases.
that's perfectly fine.
Second.
Discussion? Favor say aye.
Aye.
Opposed? You want to discuss the addendum now?
Yes,
Yes,
Sure.
yes. So essentially, this addendum to the legal report involves one case. And at the July 2024 board meeting, the board decided, actually the department had to open an administrative complaint against a licensed contractor for failing to pay a civil penalty that was issued by the board in March at the conclusion of a hearing. And this was a case where the department brought it before the board because it was a revocation case. Department asked for revocation and the board elected to assess a civil penalty at the conclusion of the hearing instead of revoking the respondent's license. Well, after the final order was issued, the respondent did not pay the civil penalty. So an administrative complaint was opened for failure to pay the civil penalty, and it was presented to the board in July at the last board meeting. And the board voted to revoke the respondent's license for misconduct, for failing to pay the civil penalty and comply with the order that the board issued. After that voluntary revocation consent order was sent to the respondent contacted legal wanting to settle the case. So right now we are presenting this to the board to get the board's opinion on what legal or instruction from the board on what legal should do. The board obviously does not have to offer the respondent a settlement that is less than revocation if the board wishes this case to proceed to litigation and wishes to hear from the respondent. Given the events that have transpired, the board can do so. But if the board wishes to offer a settlement, it can also offer a settlement. And I just wanted to get the board's opinion on what we should do.
What was the amount of the fine that they did not pay?
$5,000.
On a settle less than that.
Well, after the board voted to revoke their license at the last hearing, they contacted us wanting to settle. Of course, they still have not paid the $5,000 civil penalty. But we have a voluntary revocation consent order out. So if they want to settle for less than revocation, we obviously need to present that to the board and get the board's okay on it. Of course, the board does not have to offer a settlement. It can proceed with hearing a revocation case.
Didn't tell him at that point that he paid $5,000 to settle.
Correct, because we already have a voluntary revocation. The board has already voted on authorizing formal charges for the revocation of his license. So I would have to get the board's authority to settle before I can offer that to him.
If it helps, I think your options essentially are let it proceed to a hearing and hear from the respondent, or allow him to settle by paying $5,000, which is, I think what the recommendation was to allow it to settle with him paying that $5,000 plus the costs that we've incurred as a result of this, which usually typically that's the filing fee, but I think we're also looking at any other discretionary costs as well that would substantiate investigator and or attorney's fees time, because this is something that has gone from, you didn't pay your $5,000 to opening an administrative complaint, presenting to that to the board, filing a notice of hearing and charges, and now it's set for the November hearing. So if you prefer, we could still move forward with having that hearing and let him come and explain as to why he didn't pay that, in November, or you can allow him to settle the claim by making sure that he pays everything, and it wouldn't be dismissed until he has paid that $5,000 plus the costs.
This is the fence case.
It was heard in March of 2024. I don't know if I can look up if it involved. Yes.
Seems to me like they're delaying the process and delaying. I'd make a motion that the board make them come in for the hearing. Let's get this resolved, because they're just putting it off. They're saying they'll do one thing, then they're going to do another thing, and I think it needs to go on the hearing. That's my motion.
Second.
Any other discussion?
I was going to say settle.
I'd probably take their 5,000 and run with expenses, but a time market.
Just to type, yeah, let's type more.
Right now, the settlement offer out right now is the revocation. So what you'd essentially be doing is,
No, we have
Shane.
a new recommendation based
Right.
on it.
right, but the prior recommendation of what the settlement offer is right now is revocation based on the failure to pay that initial $5,000 civil penalty. So because they have come in and said they want to resolve this, you can change that settlement offer now to have them pay the $5,000 like they were going to initially do, plus costs. And I think you could even put a strict time limit on it, since they've gone back and forth for them to pay that penalty. So what you'd be doing is changing that. If they end up not doing it, it would still proceed to the hearing where you could consider the revocation. But right now, your consideration is whether you want to change that settlement offer to allow them to settle up for the $5,000 plus costs.
I withdraw my motion.
Do we want to place a time limit on allowing them to settle?
Yes.
Okay. What is that time limit that the board thinks is appropriate?
Generally, we give strict 30 days.
30 days. Okay. So that would be 30 days from when it would be sometime in October. We do have this set for a November 19th hearing before the board because it is a revocation.
They paid for
So if they haven't paid it,
Yeah.
it will go to the.
Okay.
It's,
All right.
Motion to that effect.
A motion to approve a settlement with costs be paid within 30 days or be heard before the board and whatever we.
Plus the outstanding 5,000, correct?
Yes.
Yeah.
That's not saying.
second.
Any other discussion? All in favor, say aye.
Aye.
Opposed? Motion carries. That was the addendum, correct?
Yes.
It's an appeal case that Justin's going to present.
Yes.
Correct.
I will step out.
Now, Ms. Sarah will step out since this was her initial case, based on the recommendation of legal counsel higher than myself. They recommended that we have a little bit of separation between the attorney who prosecuted as well as the presentation of the appeal. So I'll be handling that. I do want to, while she is stepping out, I do want to introduce, I know some of you all have met the new disciplinary attorney, Sierra Shepherd. She had a few cases on this legal report. She started with our office about a month ago. So she's doing a great job providing services, researching all of our statutes and regulations, and reviewing these cases thoroughly. So you will see her moving forward, handling more and more of these complaints. And just one other change is Kyle Johnson will be the program attorney. So he'll still have some cases he's wrapping up here, but you will deal with him mostly on the interviews and the application cases and consent orders as well, and then any rules that come through. All right. So you have received in your documents, I believe it was titled Documents for the Board to Consider, or for Board to Review on Appeal. There was an initial order that was entered as part of an unlicensed home improvement contracting case involving complaint number HIC 20230245991. I did provide, instead of the entire technical record at this point, I provided the notice of hearing and charges that explains the nature of the unlicensed home improvement violations, the initial order, which assessed the civil penalty against this respondent, and then the appeal to the administrative law judge, as well as the petition to have it reconsidered by the administrative law judge. The administrative law judge denied the request to reconsider at that level. So at this point, the only thing that is outstanding until this becomes a final order is the appeal before the board. Under the statute, because it's an appealed initial order, nothing is final until the board issues a final order. And the respondent is not represented by an attorney at this point, so he does have the ability to file a brief or an argument as to why the board should consider this case on appeal. Again, it's an unlicensed home case. If you want to review the documents, you can see that. But the two different things the board can consider at this point is, one, do we need to set a deadline for them to file that written argument? And then two, would the board like to hear an oral argument from this individual if they do file that? You do not have to allow the written or you do not have to allow the oral argument, but we do have to allow the submission of a brief or an consideration. And if they do file that brief or that argument, the board will be able to receive a copy of that, review it before this final or next board meeting, and then render a final order at that time, with or without oral arguments. This is the fence case, yes.
This is one we've already heard.
No, so this was heard by an administrative law judge on their own. So all of those cases have the ability to be appealed to the board. Essentially, it's just a safeguard for if someone thinks, either we think or the respondent thinks that something was done improperly, the board has the ability to.
What did the administrative judge decide?
To deny the petition for reconsideration. That was July 3rd.
We'll bring it back to us to decision.
By statute, we have to because they have requested that appeal. And if there are any, if you all have any conflicts of interest, that name of the respondent, please make sure you list it on the records.
Just in reading their appeal, it sounded like they didn't necessarily feel heard. And just being an effort to make sure that they don't walk away, still going that way. It's the board, I'm sure what's the best way to handle it, but just to make sure that they walk away. I've been handled here.
That's a great consideration too, because either way, the board will have to make a decision at the next board meeting on how to dispose of this, either with them coming in or not. So it doesn't really, it might take a little bit of extra time for them to present that appeal, but if you all would like to allow that opportunity.
You'll- They want to hear who you-
No, that would be it. That would be it. They would come in and explain why they think the initial order was incorrect. And then the board would have the decision either to uphold everything that was in that initial order and basically render a final order that just incorporates all of those findings and the decision, or the board could make a different decision. It went in front of the judge first. It would just be in front of you all.
It's like a $2,000.
Yes,
$16,000.
yes,
He is represented.
he is not. At this point, he is not.
There was no suspension.
No, he does not have a license. I think his concerns are kind of twofold. I think one, feels like he wasn't heard, but then two, I think that he disagrees. I don't want to speak for him, but I do think he disagrees about the requirements of the home improvement license. I don't think, I mean, if you look at the initial order, the judge found that the HIC requirements applicable in this case. And essentially that would be the decision of the board.
Right, and that the appeal didn't offer anything new that would contradict with the.
Correct. He just has that ability to appeal, and I think he is exercising that right.
We have the option of letting him come in and appeal to us verbally.
Or just through in a written brief. Either way, he has the right to submit that written brief. So you put a deadline on that if you want that submitted within 30 days, you do that. The only other decision would be, do you want to require him to submit a written brief before giving him that opportunity to show up? And Allison's trying to have a little bit of separation between the attorney who prosecuted and the board, or in our legal office. I'll be the one contacting the respondents.
I'll make a motion.
Second.
Discussion. Favor say aye.
Aye.
Opposed?
So Jesse won't get a.
As long as he submits it, you'll get a copy of it to review before the next board. And we would have the ability as well to submit a response to that.
Right, so
Correct. So then at the next board meeting, you'd receive that documentation, probably similar to all of the other documents. You make the decision at that point as to how you, if you want to uphold the initial order or change it.
legislative update for us.
There are obviously no new laws right now as the legislature is on their break. However, they are getting ready to start looking at bills to introduce for the upcoming session. So we do anticipate there will be updates, as there are almost every year, it seems. We do anticipate we'll have some updates at the next board meeting early in 2025. However, we do want to add that the rules that were authorized at the last board meeting are also moving forward the process. We will likely have shortly once those are approved by the government.
Chris, have an update for us.
All right. Good morning, board. We put an update on our staff. We are now back to full staff. Now in the auditor summer. We hired on board about a month now. So we're fully staffed, fully trained. Really well. That being said, I came on board about 5 months ago, about 4 months. I've been keeping some pretty good stats about 4 months ago. There was a lot of issues with our backlog. Applications sitting there. At the time I started keeping those metrics, we had open transactions in our system. Transactions. We have cut that down in 4 months, cut that down in half. 1,400 open transactions. It's a really good thing. We've really streamlined the processes, staff being fully trained to handle all types of applications. That's really helped reduce that backlog. So, with that being said, everybody's cases out there that I would say there are still probably duties that we're still working through that are older applications. We're still working through that, but the getting final approval button for the licenses. I'm seeing a lot of big renewals that are going to be approved well before expiration date. That was, I would say, a big problem back then. A few months ago, I would say that's no longer the case. I'm sure it's not going on right now. So we're with that, our staff was pulled in to work in the building 5 days a week starting last December. But as of earlier this month, after our town hall this month, we're on home with the exception of first being in the office every day to handle walking. So the staff has turned around and got the ability to talk and work soon. It's all the other. So that's been a real morale booster for folks. So also I think it's increased production as well. So that trend will continue. That's on that. But I also provided a report as well. Looking at we're at 34,000 active licenses in the state to include HI, LLE, and LLB. We're still continuing to see more initial applications this year than we did last year. So those continue to grow. So newer rates are still pretty high. So that will only, the new applications will turn to renewals, 2 years from now. So that population will continue. We did make some updates to our website that no longer has the verbiage saying, please get your application in before the 20th of the month, because we are sending applications to all to approve as we get them. So that's no longer a stipulation. In the future, we're hoping not to have these spikes every month of renewals. So that will kind of level out. Hopefully, it'll take some time to level that out. The way it is. So, for example, this month, September, is a heavy renewal month. So, but given our processes, we're kind of scrambling at the end. A lot of applications that are expiring here on the 30th. Keep everything that we've received so far and give provided some type of feedback. Efficiency that process. The final thing you see in here, down here is that's volume is continuing to grow. But I would say that's twofold. Still getting a lot of calls into the call center for help. That's the key. But I would say focus on is the non calling in. So emailing of getting efficient items in as stressful has helped us turn around and issue out renewal licenses. So I think that's a good thing that we're receiving more non-voice type of interactions. Get those documents. And with the application. So any questions on that? I think turn it back over to Jesse. Let's talk about kind of the complaints metric thing. I know the question that was asked last board meeting about the volume of complaints that we're seeing.
Sure. There were some numbers, I think they were provided in the packet, but if not, I'll make sure to go over them. Since August 1st, that was kind of the deadline we looked at. The last meeting was in July. Received 44 new complaints. 7 of those have already been resolved, were completed citations or administrative closures. And a lot of those were either currently being investigated on the legal report. So some of those have already been resolved or are on track to be resolved. There were 23 cases that involved formal disciplinary actions reported on the July disciplinary action report, since that came out after the board meeting. Make sure to highlight that. And 30 cases involving formal discipline actions reported on the August disciplinary action report. This totaled assessment of $130,723.15 civil penalties and assessed costs, which broke down to $55,473.15 in July and $75,250 in August. So both of those reports, those are completed disciplinary actions, whether that's citation, agreed consent order, or a formal hearing. Letters of warning wouldn't be reported as part of that for the total number, and then any case we've sent out a consent order that hasn't been signed isn't reported as part of that number. From July 1st, 2024 to present, the board's received 521 complaints, resolved 325 of them, which is slightly up from last year, as the board received 507 cases between January 1st, 2023 and September 6th, 2023, just pull those numbers. So we're up a little bit in complaints. And we currently have 6 cases set for formal hearings right now. Once those resolve, we anticipate having some more set as well. Are there any questions on those metrics or numbers that Chris provided?
Anyone have any new business? This time we can take public comment.
Chat. But once.
Oh, no, I got Adam, Nomius.
Go ahead, Adam.
Did he write a comment or is he speaking?
He raised his hand to give comment.
I do want to make sure that if you can't hear me, we might have to put this in the chat. I do want to make sure that we're not discussing any open complaints that would divulge identities of any contractors that could create a conflict of interest. Is he able to hear that? We can make public comments on items that are on the agenda, things generally related to contractor laws, but if it deals with a specific complaint, cannot discuss details.
I'm not getting a response and I can't.
I apologize.
We got
Y'all
you.
hear
We
me
got
now? I apologize for that. I was gonna say, my question was simply if a complaint has been filed and no reference was made during this meeting, I just want to confirm, I can't even just request the disposition of said complaint by giving you the complaint number. Is that correct?
You can you hear me, Mr.?
Yes.
If you want to, this is Jesse Gentry. I've got a voicemail from you that I do need to return. So if you want, we can connect after this call or after this meeting. But if it's a complaint that hasn't specifically been addressed before the board, board had a legal report with 88 cases on it. Numbers that were not specifically mentioned during the meeting may have been presented without a deviation from the recommendation of legal. So if you want to, you can either email me the complaint number, I can look it up, or we can try to touch base after this meeting to discuss it. But we can't discuss details of specific complaints.
I appreciate that. Thank you. I apologize for the technical problems. Thank you.
No, you're totally fine. We just want to make sure that if the board started hearing details of it that could cause an issue with a formal hearing. This is the reason we don't discuss the details.
No problem. Thank you.
any other comments?
They want to adjourn.
Motion, we adjourn.
Side on this case.